Okay, the claim I'll be responding to is homosexual couples have the right to marry, like any heterosexual couples. My opponent's secondary claims are: 1, denying homosexual couples the right to marry is inherently unequal, and 2, same-sex marriage does not hurt the existing institution of marriage. First, I will be responding to my opponent's first supporting claim and challenge the evidence and reasoning, and if necessary, provide a counterclaim. And second, I will reply to his second supporting claim, and again challenge the evidence and reasoning. In response to my opponent's first supporting claim, denying homosexual couples the right to marry is inherently unequal, he provides no statistical information, no testimony, and provides no citations for the facts asserted. He claims in the case Brown v. Board of Education, courts ruled separate education facilities are inherently unequal, and that the same principle applies to same-sex marriage. He then tries to support this claim, stating civil unions are different from marriage because they lack the ability to enter into a confidential marriage, long-term insurance coverage, they don't get it, and more. However, this claim is false. According to the Vermont Secretary of State website, the Vermont Act 91 states, parties to a civil union shall have all the same benefits, protections, and responsibility under Vermont law, whether they derive from statute, policy, administrative or court rule, common law, or any other sources of civil law, as are granted to spouses in a marriage. Also, the new marriage equality law, effective September 1st, 2009, discontinues the need for separate status of civil unions in Vermont. Couples currently in a civil union who want to be married can go through the new marriage process. Long-term insurance benefits are included in the Vermont law, according to the website, along with many other benefits. However, confidential marriage is not included, but this is because Vermont does not offer confidential marriages to heterosexual couples either. So my opponent claims and reasoning is thus diminished because his evidence is simply misinterpreted and false. In my response to my opponent's second claim, same-sex marriage does not hurt the existing institution of marriage, once again he provides no statistical information, no testimony, and provides no citations for the facts asserted. He only states opponents of the same-sex marriage claim that legalizing it will devalue traditional marriage, and tries to counter critics with the following, and I quote, ensuring freedom of religion didn't devalue anyone else's faith. Ending slavery and segregation didn't devalue anyone else's citizenship. Allowing women to vote didn't devalue the electoral process. This is an irrelevant argument. The textbook Advocacy and Argumentation defines an irrelevant argument as making assumptions that do not follow from the information provided. The information my opponent provides lists 3 different cases, each with respectively different issues. The quote provides no evidence to why same-sex marriage would not devalue traditional marriage. It merely makes a hasty generalization. I'm going to try to reason why they don't relate. So, for example, stare decisis is defined by legal definitions as the principle that precedent decisions are to be followed by the courts, or simply past decisions of similar court cases should carry the weight on the decision of a similar new case. So, for instance, according to the landmark cases of the Supreme Court, stare decisis was applied in the decision for a woman's right to abortion in the 1992 Pennsylvania v. Casey trial. The previous verdict of the 1973 Roe v. Wade case helped to make the court's decision. So they acknowledged it there, and then they used the same to acknowledge it in the Casey trial. You cannot consider a case on a woman's right to vote with same-sex marriage. So they are not related. Stare decisis would not be valid in that case, or would it if you're trying to compare slavery or religious freedom to same-sex marriage. It just doesn't work. In conclusion, my opponent began his argument praising his main claim as a claim of policy, not a claim of fact. And throughout his argument, he lacks factual evidence to support his claim. The support for his secondary claims are based solely on my opponent's own knowledge and opinion on the subject, ignoring the expertise or facts of those who are more qualified to give them. In fact, his justification for his claim is, and I quote, my main reason is there's really no reason that I have been able to see to deny them the right to marry. This states his whole argument. He appeals to ignorance by asking the audience to accept a claim solely because no proof exists to deny its validity. And that's
All right, the structural stuff is fine. I think maybe you're doing a little too much road mapping. It's basically you give a preview of each of the secondary arguments that you're going to be giving instead of just reminding us what the supporting points would be, and then you give us your arguments about it, and then we get to the argument. It's a little convoluted to go through that whole process. So just keep it simple. Remind us what the points are that you're going to get to, and then make your arguments as you get to each of them. You challenge the information on the first point. That was okay. That you suggest that the application of the Brown versus Board of Education thing is not a legitimate application, but your argument on why it's not a legitimate application needs to be a little bit clearer. The argument about civil unions not being the same as marriage or not having the same rights, your example of Vermont attempts to refute that by showing that they have the same rights in Vermont. I'm not sure that outside of Vermont any of this would apply, but it's a good answer for this particular argument. There's a presentation or a discussion of confidential marriages, but there's not really an explanation of how confidential marriages are different from either regular marriages or civil unions, so I'm not sure why that applies at all and why we're getting into it. The second point, signposted very clearly. Again, you got a challenge to the lack of evidence that the advocate presents. I thought that you had a nice explanation of the reasoning problem here. You labeled it a fallacy of relevance. It sounded more to me like there's an argument about the legitimacy of the analogies and whether or not they are comparable. So I think that you've got the right argument, maybe the wrong label on that argument. The explanation about stare decisis is interesting, but the explanation about how it applies in this particular situation was not clear, except that you just kind of say, well, voting's not the same thing as same-sex marriage. I'm not sure that the advocate's saying that it is exactly, but I'm not sure you've explained why they don't have the same principles involved, and so that needs to be elaborated on. I did think that you had a good analysis of the closing point of the advocate by suggesting that it is an appeal to ignorance because they can't see a reason not to have it, suddenly becomes a reason to have it. That's exactly what an appeal to ignorance is. So I thought the label on that was really clear. Okay, thank you.